Our topic for today is landlord-tenant law, and I'll keep the introduction here short and sweet. We're pleased to have Larry McDonough, who's a senior fellow um, with the National Housing Law Project, and he will be here talking about the changes to the landlord-tenant law. So I will go ahead and turn it over to you.
All right, thank you. Can you hear me okay? Give me a
Yes.
thumbs up. There we go. Okay, good. So I just want you to see my face before I go into the slideshow, not to scare you, but just so that you know who's talking. So my name's Larry McDonough, and I've been in the area of landlord-tenant law for a long time. First in the legal aid world for about 30 years, more or less, and directing pro bono at Dorsey and Whitney for about 7 years, and at various nonprofits as well. So this is what I do, and so hopefully I can shed some light on some of the new laws here. And if we have some extra time, and if any of you are music nerds, I can tell you about that really nice Yamaha grand piano in the back and why it's there. But we'll just have to save that for now. So what I'm going to do is pull up my slideshow again. And I'm going to make it into a big screen. So that means I will not be seeing the chat, but I think Sarah might pop in now and then with questions or comments that you have. So I'm just going to get us started there. Okay. So talking about landlord-tenant law, it changed a little bit. And well, the laws were passed in 2023. A few of them went into effect in 2023, but for the most part, they've gone into effect in 2024, just about a week ago. And just so that I'll keep us on time here, we're scheduled for 90 minutes. And I'm going to have my phone off to the side here so I can keep track of the time and keep us on track. So let's move on down. So this is information on me. I serve both as a senior fellow at the National Housing Law Project. We assist mostly legal aid attorneys around the country in their practice of housing law. I'm also a policy attorney at Homeline, where I work on legislation. And so I worked on a lot of these bills. I've got my contact information both here and at the end of the slideshow. And so if you ever want to reach out to me with a question or comment, feel free to do that. You can use any of these emails or the cell phone here. I also maintain a housing law website called Housing Law Minnesota, and there's a link to it on this slide. And I understand you will be getting the slides afterwards, but I also put into the chat my website where the, I think it's the very first item in the chat today, is my website where this is housed. So on this website, I have a lot of information for practitioners, including a very large manual on landlord-tenant law. And just in case you think I'm biased in all this, I've been doing this for a long time, and I've represented both landlords and tenants. I've done more tenants than landlords, but I've definitely represented landlords, and I've been a landlord as well. I've also had my bio down there at the bottom of the slide, but you only want to go there for comedic purposes because, like all of our bios, it's just a pack of lies. So links to the new housing laws. The main laws are in Chapter 52 of the session laws from 2023. There are some related to landlord-tenant law in the cannabis law, which is Chapter 63. And there's a little bit related to sober houses in Chapter 61. And the only reason I mention that is that by the references that are there, it's my belief that they are now governed by landlord-tenant law. I think they always were governed by landlord-tenant law because of the expansive definitions of landlords and tenants in 504B.001, but I think this makes it a little more clear. Now, when you see underlined portions in the slideshow related to websites, those are active links. And so if you had this slideshow and you wanted to hover over Chapter 52 and you clicked on it, it would take you to that. You'll also see other underlining in this slideshow, and that is to show you basically the markup on laws that change the old laws into the new laws. Okay, so first we're going to start with evictions. I think this is probably the area that would most impact court personnel. although there definitely are other sections in here that would have an impact on the courts. Okay, so the first one is right to counsel in public housing breach of lease cases. And so if you were to click on the link here, if you had the slideshow, it would take you exactly to that language. But I also put into the slides the language, so you don't have to do that. And even though this is a fairly long slideshow, about 75 slides, we'll move through it relatively quickly. But I like having more content rather than less content in slides. So there's a new statute, 504B268. It's patterned off of other right to counsel statutes that we have in Minnesota that allows, in certain types of cases, indigent individuals to request an appointment from a judicial officer in an active case for a free attorney. But it's important to note that this only applies to public housing cases involving breach of lease allegations. So public housing is a very small swath of the landlord community. And tenants know if they're in public housing, they have a public housing lease. Public housing is not synonymous with other types of subsidized housing. It's basically a term of art. It refers to housing that is owned by the government, usually a local public housing authority or housing and redevelopment authority. And they receive their funding from a specific pot of money from the federal government for public housing. So it only applies to public housing, not subsidized housing, not Section 8 vouchers, not project-based subsidies, not low-income housing tax credits, or any of the whole alphabet soup of subsidized housing programs. And then within the, if you want to talk about Venn diagrams, so we got the big diagram of landlords, and we shrunk it down a little bit to public housing. Now we're going to shrink it down more to breach of lease cases. So not non-payment of rent cases, which are by far the vast majority. We conducted some research of publicly available public housing breach of lease eviction files. We did this in around 2017. We looked at 2016. We found 60 statewide. So not a lot there. And there may not be a lot of tenants asking for appointment because they may already be represented by a legal aid office. But if they're not represented, then they can ask the court for that. The complaint from the Public Housing Authority for the eviction case needs to make note of this law. The judicial officer is to inquire of an unrepresented tenant in a public housing breach of lease case if the tenant needs representation. And the law talks about the qualifications of attorneys to be appointed and their compensation. And that went into effect August 1, 2023. So now I'll just show you what the law looks like. It's 504B268. This is the part that says that the tenant has the right to make the request, that the complaint has to have language in it, and the court shall ask the defendant if the defendant wants a court-appointed attorney. Qualifications here for appointment: 2 years minimum experience handling these types of cases, or having had training on it, or being supervised by an attorney who meets these qualifications. So if there's anyone from a district who has some attorneys that want to be qualified, but they don't fit these qualifications, I'd be happy to provide training for them, and time permitting would be willing to supervise them as well. The compensation is basically set up by each judicial district, and this is similar to what is done with other types of right to counsel, like in guardianship, commitment, things like that. Okay, this went into effect August 1. Now, the effective date of almost all of the other changes in Chapter 52 was January 1, 2024. So I'll point out the exceptions when we get to those exceptions. Okay, so first one, and I'm taking these somewhat in a numerical order of how they appear in the chapter, so it might seem a little random, but that's the choice I made in putting this training together. So there are several changes to laws that deal with the issue of when a tenant can be required to pay rent into court. Okay, so the background on this is in an eviction case for non-payment of rent. The Fritz case talks about the tenant paying prospective rent into court if the case is going to drag for a while. Doesn't say anything about the paying into court the rent that's in dispute. But there have been a number of courts around the state that have ordered tenants to pay the disputed rent into court. And if they don't, their case, they lose. And so there were several changes that were made to make it clear that when courts order tenants to pay rent into court, it's for prospective rent as it comes due. It's not for the rent that's in dispute. And, in my mind, that makes sense. That's consistent with other types of litigation where if Company A sues Company B for $1 million, Company B doesn't have to place $1 million into the hands of the court to defend the case. So this is one of those statutes, and I'll point out the other as we get to it. There were rent posting requirements in cases where a landlord combines an allegation of non-payment of rent and breach of lease, and this change eliminates those rent posting requirements. Redemption is the concept where when a landlord files a case against a tenant for non-payment of rent, the statute actually says it's a demand for the rent, and a tenant has the opportunity to redeem the tenancy by paying what the court orders the tenant to pay. And so that normally would be whatever rent the landlord's proven, other fees that the landlord's proven, the landlord's disbursements, in other words, their filing fee, that type of thing. And what this amendment does is allows the tenant to redeem by obtaining a written guarantee from an agency or a nonprofit that administers a rental assistance program and has sufficient funds available and guarantees that the funds will be paid for the landlord. So if the tenant obtains and provides that guarantee by the deadline that the court gives to the tenant to redeem, the submission of that document constitutes a redemption, and that the court should not evict the tenant, should not further the eviction process. Probably the biggest change is in 504B 321, and the biggest aspect of that change is a new pre-filing notice requirement for non-payment of rent cases. So I'm gonna kind of move on to basically that's in subdivision 1A. What D says on this slide is that that type of notice needs to be attached to the complaint. Now, it only applies to non-payment of rent cases. So the landlord were, well, we'll get to that in a moment, but that's for a non-payment of rent case. So this is the new written notice requirement. And just to back up again to effective date here. Effective date is January 1, to actions filed on or after that date. Okay, so now we're going to move back to where we were. So and this is the complaint and summons section, and it talks about the pre-filing notice. So if a landlord filed a case on December 27th, this would not apply. If the landlord filed the case, if they wanted to file a case on January 2, the odd timing of all this is that that case would need to be preceded by the notice that we're now going to discuss. So there's a little window of time here where if the landlord was planning to file a case, if I were a landlord and I was planning to file a case on January 2nd, looking at the new law, I would have given the 14-day notice 14 days earlier so that I'd be ready to file that case on January 2nd. So unfortunately, when you have effective dates and the law changes, you sometimes have short windows of time where things are a little bit confusing. Okay, going on to the notice before bringing action for non-payment of rent. Landlord has to give a notice, needs to include the total amount due, a specific accounting, so essentially a breakdown of it, names and addresses of the person to receive that on behalf of the landlord, and then several statements about the right to obtain legal help. And this is quotation statements, so this needs to be in the notice about financial assistance, and that the landlord could file the eviction case within 14 days if the tenant doesn't pay the total amount. Needs to be delivered either personally or by first-class mail. I've gotten some questions at other trainings I've done. I've been doing a lot of training on this. Well, does personally mean personally slide it under the door? You know, the statute doesn't answer that specifically. Usually when the word personally is used in statutes in landlord-tenant related to delivery of notices and service of summons and things like that, it's meant to be received personally. And so my advice to landlords is if you want to do personal, go to the property. If you can find the tenant, give it to the tenant. If you can't find the tenant, then mail it by first-class mail. Then the tenant has 14 days to correct the delinquency. In other words, pay the rent. And if not, the landlord can file a case. Now, so I'm sure there's some landlords that aren't happy about this. Essentially, it's a 14-day delay on when you could file a case. When I was a landlord, I gave a similar kind of notice anyway, because I figured if I could start a conversation about getting the rent paid, I might not need to file a case, because either we work out a deal to get it paid or the tenant moves. But one thing that hopefully will be attractive to landlords is that this notice that they now have to give meets a couple of qualification standards for the payment of emergency assistance. So emergency assistance is a government program that can help people with low incomes pay certain amounts of money to resolve an emergency. So the emergency with an eviction is impending homelessness. There's certainly been problems over the years with some emergency assistance agencies requiring a lot of documentation out of a tenant and the landlord while the clock is ticking in terms of the progress of an eviction. So the nice thing about this is hopefully this will streamline it by being a verification of both the emergency and a verification of the amount that needs to be paid. So I'm actually hopeful that this new notice requirement will actually lead to less evictions rather than simply prolong evictions by starting a conversation between the landlord and the tenant about the rent, about providing more of a fast track for emergency assistance. Okay, there was a change in expedited procedure. These cases are so rare that I think I'm just going to skip past that. An expedited case doesn't move much faster than a regular case, and it's got some pitfalls for landlords in terms of service of the summons and complaint. And so generally, I think it's a bad idea for landlords to file that case. If they really want to, they can do it, but it's got some minefields in it. But if a landlord does file an expedited case, I think the more important change here is that it makes clear that an expedited case can only handle expedited allegations, and the landlord may not supplement those allegations with kind of non-expedited breach of lease allegations. Okay, contents of the complaint. If alleging non-payment of rent, need to attach the notice and need to, and then attach the notice. If it's a breach of lease case, then the landlord needs to attach the breach, attach the lease, but also go into some detail about the case. What this is really getting at is, even though for a long time I felt that our current statute, which requires the landlord or and I'm mostly going to use the word landlord because most eviction plaintiffs are landlords, but there can be other eviction plaintiffs, contract for deed vendors and mortgage foreclosure cases, but those are not real common. So I'll probably just keep continuing to use the landlord when I'm talking about a plaintiff. Okay. currently, the landlord has an obligation to plead the facts which authorize recovery of the premises. So basically fact pleading rather than notice pleading. So I've always felt that detail is the requirement. But, we've seen, inconsistent decisions in district courts around the state on that topic. And so now this makes it pretty clear. If it's a non-payment of rent case, you attach that detailed itemized accounting. If it's a breach lease of case, you go into the details of the breach and what the conduct was, when it occurred, who did it, that type of thing. Let's see. And this is kind of more aspects of kind of pleading in detail. Let's see. And then this last one here has to do if you have a case, if there's a case involving subsidized housing, that be pled as well. And part of we'll get to the reason for that in a moment, but the main reason for that is that to alert the court that there are additional laws and regulations that may come into play in the case because the housing is regulated by a government program. Okay, the little difference in the summons, and that the summons needs to have some information about how the tenant's going to participate, and have these similar statements to what was in the complaint about getting legal help and financial assistance. Subdivision 5 says that the court must expunge the record of any case if the person bringing the action fails to comply with this section. So really everything I've said is what needs to be strictly complied. And that's the point I've been making with landlords is don't try to kind of game anything that's in here by doing shortcuts or anything. I mean, if I were a landlord, I would be looking at this law and I'm going to file it head to toe. I'm going to follow it head to toe. Okay. Now, kind of going hand in hand with this new 14-day notice law was getting rid of a different 14-day notice provision in another law. They are a little bit apples and oranges, but if the two 14-day notice laws remained, I think there would have been some confusion about which ones landlords need to follow. And this 14-day notice requirement in 504B135 was really rarely used. So this, I think, was more about eliminating possible confusion than concluding that this was an inherently bad provision that needed to be renewed. So I want to talk a little bit about the effect of this new law on the current laws for non-payment of rent. So before this law went into effect, most landlords had no obligation to give any kind of notice of non-payment of rent, but some did. In the city of Minneapolis and city of Brooklyn Center, there are ordinances that already required a pre-eviction notice to the tenant. 14 days in Minneapolis. In Brooklyn Center, longer, 30 days, but only in what's affordable housing as defined in the ordinance. Okay, so when you look at the new law, which is statewide, and let's say you have a landlord with a property in Minneapolis, the landlord will need to comply with the content of the Minneapolis ordinance notice and the content of the state law. And now in Brooklyn Center, the Brooklyn Center has a longer notice requirement than the state law. So reading those together, the landlord would need to give a 30-day notice, but only if it's in affordable housing. They have to do a 30-day notice that includes the content from the Brooklyn Center ordinance, but then also the content from the new state law so that they're in compliance with both. Now in St. Louis Park, we have a shorter notice, a 7-day notice for non-payment of rent. So a landlord there would need to give a 14-day notice to be compliant with the new state law and include the content from the St. Louis Park Ordinance and the content of the new state law. So in manufactured home parks, under 327C.09, there's a 10-day notice for non-payment of rent. Now, so now we have a conflict between two different state laws, and we have laws on how to resolve those conflicts. And one of those components is you look at the most recent pronouncement as being overpowering the older one. So when I look at these two laws, what I see is that the manufactured home park would need to give a 14-day notice, including the content of the state law, to be giving a proper notice to a mobile home park resident. Now, when you look at public and subsidized housing, they're governed also by state law, but also federal laws and regulations. And there's also a thing called the CARES Act. You might have heard of that back in 2020. It was the law that created enhanced unemployment compensation benefits. It also had the first national eviction moratorium for what are called covered properties, which was like public and subsidized housing and properties with federally backed mortgages. That law also had a notice requirement, a 30-day notice requirement before eviction. And while some aspects of the CARES Act have expired, this provision has not expired. So for a landlord in public and subsidized housing, they would have to give a 30-day notice to be compliant with the CARES Act, but then have the content from the new state law 14-day notice in it. So a 30-day notice, but the content of the state law. And the last bullet is similar thing for landlord with a federally backed mortgage, because the CARES Act applies to those properties as well. So if a landlord has a federally backed mortgage, Freddie Mae, Fannie Mac, that type of thing, then they have to give a 30-day notice under the CARES Act, but then include the content from the new state law. Now, just like on other slides, on this slide, if you were to go to any of these links and select them, they would take you to the source material, like material talking about the CARES Act, the different ordinances, and things like that. Okay, the next up are a couple of changes to really deal with the fact that a law was repealed back in 2001, but we continue to have some references to that law. That law, 609.5317, had to do with when there's a seizure of contraband on the property that a landlord could assign, or a county attorney could handle the eviction case for the landlord. And that was repealed back in 2021, but there remained a couple of references to that. So the changes here simply delete those references. One of them's in 504B301, and then another was actually repealing 504B305. But I put in a bracket here what that used to say. So that's no longer on the books. And so that was more, I think, of a housekeeping thing. Okay, now going to the summons, the statute and the summons. One change here, I find this to be kind of a modest change, is in A, deleting the reference to who can serve the summons. So all that means is that we then look to the Minnesota Rules of Civil Procedure, Rule 4, which tells us who can serve and who can't. There have been a couple of changes on pretrial procedure. And one is to give the courts more flexibility in the scheduling of hearings. So the law before this went into effect was that the court had a continuance statute that required it in most cases to limit a continuance to only 6 days. And so where a continuance comes up in landlord-tenant practice is landlord files a case against tenant, and there's a first court hearing. We often call that arraignment, even though that's not a word that shows up in 504B. And so there often are a lot of cases scheduled at the same time. And then if the parties don't reach a settlement, or neither one's in default, or the case isn't dismissed, if none of those things happen, then there's going to need to be a trial. And under the previous continuance statute, courts were limited in how far they could put that out. Now, normally, the courts would say, okay, landlord, tenant, when are you free? Okay, looking at your schedules, you're both free 2 weeks from now, so we'll schedule it from then. Nobody objects, and that's what it is. But one side could say, well, wait, you can't push this out any more than 6 days. I frankly think the court had the inherent authority from a separation of powers analysis to do that anyway. But this makes it clear now that the court has flexibility in the scheduling of the case, essentially based on, I would say more or less the complexity of the case. Let's see. Now, yeah, this change here has to do with scheduling, and essentially it swapped out some of the language regarding nuisance and put in language that is a little more descriptive of what would be a priority case. Now, I mentioned earlier about the whole issue of requiring tenants to pay rent into court. And the earlier slide had to do with a case where a landlord's combining an allegation of breach of lease and allegation of non-payment of rent. And the whole provisions related to posting rent into court were eliminated. Here, what was done is to make it clear that any requirement of the tenant to pay rent into court is rents moving forward, not rents moving backwards. And we'll talk about another example of this type of rent posting change when we get to talking about appeals. Okay, judgments. If the court finds for the defendant, the court shall enter judgment for the defendant and also shall expunge the eviction record. And we'll be talking more about expungement changes in a few minutes. Now, the change here has to do with staying a writ. So what the landlord's after an eviction case is a writ of recovery. And that's the order that says the tenant has 24 hours to move. And so if the court awards that writ to the landlord, the court can stay that under previous law up to 7 days if there would be a hardship on the tenant. So that would mean the landlord would have to wait 7 days before the landlord could get the writ of recovery from the court and then take it to the sheriff to enforce it. So this change kind of flips it around a little bit. There, the tenant had to show it would be a hardship for the tenant to move earlier in order to get a stay of this writ for 7 days. And I think what's happening here, this change more reflects the reality that I think most judicial officers have come to the conclusion that any tenant having to be evicted in less than 7 days is probably a substantial hardship. And so what this does is say that the tenant gets 7 days unless they're engaging in this serious behavior that's now outlined in the statute. Okay, motion to vacate judgment. These don't happen often in eviction cases, but they're certainly not uncommon. And this is to make it clear that a tenant can, well, actually any party, more often it's a tenant, but that a party can bring a motion to vacate a judgment, and an order denying that is considered a judgment for the purposes of appeal. So the reason for this is the appeal time in an eviction case is pretty short. It's 15 days from entry of judgment. For anybody who's done appellate litigation, that's a fairly short amount of time to get everything together. And so if the clock's running on that, and you're considering doing a motion to vacate a judgment, the clock might run away from you while you're having that motion being heard. And so this is to really clarify that a post-trial practice of doing a motion to vacate a judgment is authorized, and that an order denying that motion would basically start an eviction, an appeal clock at that point. Okay, we've got another statute on summons content. I think the big thing about this is that the summons includes the language that we discussed earlier that was in the complaint. Okay, now on to appeals. So this is where we get to the change regarding posting rent in order to now stay in the property during an appeal. So what we're talking about now are supersedeas bonds. So this is the bond that an appellant needs to pay or post in order to have the district court stay its order to allow the tenant, allow the party to appeal and not deal with the effect of that order. So in an eviction case, often what that would mean is the tenant wants to appeal. I mean, landlords sometimes appealing, but this is more of an issue for tenants. That the tenant who's appealing, if they want to not be evicted during the appeal, then they have to post or pay a supersedeas bond that the court approves. And some courts would, I mean, I always advocated, as from a tenant standpoint, and I did not oppose this when I was representing landlords, that that bond be the rent as it comes due while the appeal is pending. Because the whole idea of the supersedeas bond is that if the appellate loses, but the respondent was delayed in enforcing his or her or its order, that the bond was there to essentially compensate the respondent for whatever that hurt was. And the obvious hurt in an eviction case would be that if the landlord wasn't getting the rent for 9 months and the tenant loses, tenant gets evicted, the landlord would be out the rent. So what I always advocated is if the tenant just pays the rent as it comes due and doesn't damage the property, that the landlord isn't going to get hurt. But some courts, there have been some courts that have said, tenant, you need to pay the rent that's in dispute, or you need to pay 9 months of rent upfront right now. And like other rent posting requirements that we discussed earlier, there can be a due process issue with now someone's being precluded from litigating a potentially meritorious claim because they can't pay upfront some amount of money. So the changes here with the appeal bonds is basically say, like with what we discussed earlier, it can be amounts going forward as it accrues, but not going backwards, not a lump sum, not looking at amounts that were in dispute. So there are a few of these changes here that all really get to that point. Okay, I'm going to take a drink of water here. Sarah, are there any questions that have popped up yet that you want to run past me, or should I just keep going?
I have not seen any questions yet, so if you want to carry on, if any come up, I will let you know.
Okay, sounds good. So now I'm going to talk about expungement. So expungement is the process of making a court file no longer publicly accessible. And there's been a lot of confusion around what expungement is. And so I want to try to clarify that right now. There's a definition in 484.014 of what expungement is. It is not destroying a file. It is not hiding the file from judicial officers. It's not hiding the file from court staff. It's simply not making it publicly available. And so I've heard, sometimes from court staff saying, well, no activity can occur on an expunged case. And that has more to do with how a court system has set up its processes. It has nothing to do with the definition of expungement in 484.014. There's no reason from a legal standpoint that an expunged case cannot have some motion practice activity going on in it and still not be available to the public. So that has more to do with how courts' computer systems work and how about court processes. So let's go into the changes now. There are two types of expungement under the statute, discretionary and mandatory. And the discretionary one had several components to it. And what this change does is removes a couple of those components and really gets it at the issue of what the common law says about expungement. So we already had common law on expungement, and it basically focused on a balancing test between what does the public have an interest in being access to this file, and does the tenant or does the party have a justice interest in having the public not see it. And, be honest, I'd say the public here is not the larger public. The public here would probably be the landlord subset of the public, because I've never met anyone who just out of idle fun goes through the court's public database and looks at eviction files just for entertainment purposes. But anyway, so what this change does is it conforms discretionary expungement to the existing case law that we have on common law or inherent authority expungement. So that's one change. The other change was to expand out the different types of mandatory expungement. And so one change here is that a party doesn't have to request it, that the court shall expunge in certain categories. Now, two of these categories are the first two on the slide that were already there. They came out of the foreclosure crisis from the first decade of the 2000s. And these bases were more common then than they are now. But what was added to that was a list of other cases where the court shall expunge. If the defendant prevailed, and again, now we're, so keep in mind, defendant most often is a tenant, but could be a defendant in a mortgage foreclosure or contract for deed cancellation. Defendants prevailed on the merits, the courts dismissed the plaintiff's complaint, the parties have agreed to expungement 3 years after an eviction was ordered, or upon the motion of the defendant if the case is settled and the defendant fulfills the terms of the settlement. So the last one, number 6 here, the defendant has to make a request of the court. 2, 3, 4, and 5, and actually the 1 and 2 that were on the previous slide, those are ones that the court shall do, and it is not, there's no precondition that the tenant should ask for it. Now, I know I've heard some conversation about, well, when does this 3-year after the eviction part go into effect? And my answer is it goes into effect right now. And so my opinion is what the courts ought to be doing is looking back to evictions orders from 3 years ago and then more current than that and start expunging them. I've heard some say that, well, that means this is retroactive. And my belief is that it's not retroactive, but it's saying that as of right now, the court has an obligation to expunge a file that is 3 years old or less. And, I'd be interested in if people have opinions on that, but that's how I read the law and its effective date. I know that that's not a simple thing, and different courts may have technological issues with doing that, but that's my opinion of what number 5 says here. Eviction records, there was a provision in, so all that was in 484. There was a provision in 504B and 321 that was related to what we just discussed, and it would have rendered the eviction file private until there was a judgment. but that was invalidated by a decision of the Minnesota Supreme Court back in August. And like other things, when I have citations here and they're underlined, if you were to select that link, it would take you to that order. I don't think the story is done on this issue. I think what the court was doing is saying, we have our rules of public access to court data. That's the venue for this, not the legislature. So I would not be surprised to see a petition to the Supreme Court to do something like what this law was intended to do. Okay, I'm gonna take another drink of water here. Now, I'm going now into a few laws that were changed that have more to do with just landlord-tenant rights, but because these laws might come up in eviction cases as well as other types of cases, I thought I'd discuss them in the section dealing with evictions. So there was change in the privacy law that made clear, previously the landlord had to give simply a reasonable notice. It didn't have any time or content parameters on it. Now it has to be not less than 24 hours and has to specify a window of time when the landlord wants to come to the property. Now this one is effective at January 1 and applies to leases signed on or after that date. So that's a little different than what we've just been discussing previously, were an effective date to actions filed on or after January 1. So this applies to leases signed on or after January 1. So you could have an eviction case that's maybe filed in February, but if the lease predated the effective date, the changes to this privacy law would not apply in that case. That's one of the reasons why I'm not a big fan of having this type of language in an effective date, because then it makes it, then you end up having this kind of gray period where a new law that's in effect governs some people but doesn't cover other people just because of the passage of time. But it is what it is. I think it would apply to any tenancy that began on or after January 1. Little bit unclear as to how this would apply in a month-to-month tenancy. In an oral month-to-month tenancy, nothing is signed. It's just landlord says, move in 1st of January. Tenant says, okay, and nothing's in writing. I doubt that the legislature intended this law to not apply to month-to-month tenancies. So will be interesting to see what the courts do with this, and if the legislature decides to make any change on that effective date. But that's how it reads right now. So why am I talking about that in the eviction setting? Well, it's because the change here in subdivision 6, it makes it clear that the tenant can raise this issue in eviction cases as well as other types of cases that the tenant could file against a landlord. It also increased the penalty for violations. So previously, a tenant would not have been able to enforce this statute defensively in an eviction case. Now the tenant can, as soon as it applies to that landlord and that tenant. So unfortunately, in terms of applying this law, there needs to be an analysis of is this tenancy based on when it originated, is it covered by this law or not? There's a new law that adds to our habitability laws that requires the landlord to furnish heat at 68 degrees. And that was effective on January 1. And because tenants can raise habitability violations defensively in an eviction case for non-payment of rent, a tenant could raise a violation of this new provision as well. We have a law on crime-free leases, but that does not go into effect until June 1, 2024. This gets at the issue of crime-free ordinances that require landlords to police the conduct of their tenants on or off the property. And there are a lot of landlords that didn't like having to police conduct off property, and tenants didn't like landlords being in the business of policing their conduct off property. So what this does is says the landlord can't evict or impose a penalty for a tenant's conduct and household members and the like and guests off the property, with a couple of important exceptions. That the conduct would constitute a crime of violence against a tenant, tenant's guest, landlord, basically against people on the property. So the conduct occurred off-site, but it was a crime of violence against somebody who is connected to the property. And the second would be a crime of violence against anybody else if there's a conviction. So the first one doesn't have to be a conviction, just landlord would have to prove that the tenant engaged in this conduct, and it would constitute a crime of violence against the people that are listed there. But if someone has been convicted of a crime of violence against anyone, that could be grounds to evict. But this does not go into effect until June 1, 2024. It also doesn't have any qualifications on it, like when the lease was signed or things like that. So this just kicks in June 1, 2024. Gonna look at our time here. We're at 12:52. I think we're doing pretty good. Okay, there's a change in the attorney's fee statute. This statute essentially creates, if the landlord has an attorney's fee provision in the lease benefiting the landlord, this statute creates a mirror image right of the tenant. And there was an unpublished Court of Appeals decision that limited the application of that to only cases where the tenant won on the merits. And so this change basically expands out the statute and essentially overrules the equity residential holdings case by saying if the case is dismissed or the tenant wins on other grounds other than the merits, the tenant would qualify for attorney's fees under the statute. Okay, we had some laws related to cannabis that have an impact in eviction cases. One is in the area of expungement. It has a new expungement ground in mandatory expungement related to evictions involving marijuana or other types of cannabis. I think this will have very limited effect because I've done this for a long time. I probably have 11,000 former clients. I could only probably think of a handful of cases that were based, for instance, solely on marijuana. So this went into effect August 1, 2023. I don't think it's going to have a big impact. Next one's a little bigger impact. In the unlawful activity statute, well, first of all, since cannabis, for the most part, within certain parameters, has been decriminalized, that possession of cannabis, that the quantities and the types that have been decriminalized would not be an unlawful activity for the purpose of this statute. This statute allows landlords to evict tenants for certain types of unlawful activity. But another part of this is the landlord can't prohibit the tenant from possessing the products that are listed here, but the landlord can prohibit basically smoking or vaping of cannabis products. This went into effect August 1, 2023. There were other changes in the cannabis law that do impact landlords and tenants. I just wanted to highlight those. There's a lot of information about what one can possess and what they can't possess, and that's in Article 1, Section 9. There are a couple of provisions against anti-discrimination for people that are in registry programs. There's a provision that allows for a nuisance action related to use of cannabis that I don't think is really going to amount to much. There's a limitation on cannabis and multi-housing buildings that doesn't go into effect till March 1, 2025, and is actually inconsistent with the last slide that I presented on landlords not prohibiting certain types of cannabis. This was a very big law, and different parts were probably written by different people. So you had a little bit of left-hand, right-hand thing not connecting. And I suspect that sometime before March 1, 2025, there'll be some reconciliation of those two provisions. Okay. Now,
Larry,
the issue, oh,
Larry, before
yep,
you move on, we do have one question in the chat.
yep.
The question is, what is the landlord's right to evicted tenants' personal property?
Okay. I'm taking that question means, does the landlord have the right to take the tenant's personal property? Because an eviction is really an eviction of a household. And so if a landlord, let's say a landlord evicts me and I lose the case and the court gives me a certain amount of time to move, and then I have to move with my stuff. If I don't move with my stuff, there's a law that requires the landlord to hang on to that stuff for 28 days and kind of goes through the process of that. The landlord doesn't have the right to throw out my stuff that I've left behind the day after I left. I suspect that's what the question was getting at. I hadn't gone into that because that law wasn't changed at all by the 2023 legislature. And if I missed what the question was, feel free to ask it again, and I'll try to do a better job. But I do want to make clear that the landlord really has no right to go into the tenant's apartment and take the tenant's property. Okay. So the whole thing about cannabis does raise the question, well, cannabis is still illegal under federal law. And so how does that play when people live in federally funded public and subsidized housing? Most of those programs allow landlords to terminate leases for different types, for essentially drug-related criminal activity. They generally don't require landlords to do that, but they authorize landlords to do that. So the question is really going to be, how is the state law and the federal law going to work together? Are they going to coexist? Is the federal law going to preempt that? Is there a way to reconcile the two? We'll just have to see how that goes. I have a section in a manual of mine that kind of discusses kind of the interplay between federal law and state laws. So that's one we'll just have to see. Okay, now I'm going to talk about other landlord and tenant laws that aren't kind of connected to eviction cases. I'm going to move through some of these relatively quickly, so we'll have a little more time at the end for questions. Frankly, this was something I didn't know was a thing, that apparently some landlords allow tenants to have pets, but might require them to be declawed or devocalized. And actually, I didn't even know what devocalization was. So this is a law that essentially says landlords can't do that. Now, landlords don't have to allow pets on the property, but if they do, they can't require the tenants to do declawing or devocalization. And so there are a number of definitions here of those terms. And then we've got the prohibitions, what the landlord can't do, and the penalties for what happens if a landlord does those things. We have a law on fee disclosure. Unfortunately, it's kind of inaccurately titled as prohibited fees. The reason for that is this law was originally going to prohibit landlords from having non-mandatory fees to tenants. In other words, some landlords have a $200 administrative fee every January. And tenants might not have noticed that in the lease or might not have seen it in an advertisement. So the original idea was to prohibit those fees, that you lump everything into the rent that's mandatory. But you could have other things on top, like if you want to have a premium parking spot, you pay this amount. Well, then that would not be mandatory. It was changed during the session to make it a disclosure law rather than rather than a prohibition law. And so landlord has to disclose non-optional fees in their advertisements and the lease agreement. And so just to kind of make it clear, like a late fee is not a non-optional fee. You only pay a late fee if you pay the rent late. So that would not have to be separately disclosed. But let's say landlord says you have to pay your rent through this portal and you've got whatever, a $5 convenience fee, because I'm an old cranky guy, I like to call those inconvenience fees. If that's the only way the tenant can pay, then that would have to be disclosed. If the tenant has the option of paying a different way and avoiding the fee, then it wouldn't. Okay, security deposits. There were a couple of changes in security deposit laws that require the landlord to offer both an initial inspection of the property to basically document the condition of it, and to offer basically an exit inspection as well. And so that's what is in this. So, and there's some details on what is the inspection and how it's arranged. Okay, so then I will continue on. There's a lockout action is a case that a tenant files against a landlord if the landlord excludes the tenant from the property without going through the eviction process. And this one simply reduces the filing fee for a lockout case to be the same as in conciliation court. The rent escrow case already had a reduced filing fee, so this kind of just brings it to be consistent with that. There were a number of changes to the emergency tenant remedies action. This is a case that a tenant files against a landlord for emergency repair problems. And so as you can see, what was struck out was a list of basically conditions. And what that was swapped out for a longer and more detailed list. So the first one would be if there's been a license revocation or a condemnation that is now kind of excluding the tenant from the property. And then other types of emergencies, infestation. Now, some on this list were already on the previous list, like the running water, hot water, heat, electricity, sanitary facilities, and then added in are then additional ones, non-functioning refrigerator, if included in the lease, a non-functioning air conditioner, if included in the lease, a non-functioning elevator, and then kind of a catch-all here related, serious or negative impact on health or safety or other essential services. So it really broadens the list, because what we were seeing is under the existing list that some courts were saying, well, if it's not on this list, then we're not going to call it an emergency, even though there was a catch-all provision for other essential services. So now we've got, I think, a more comprehensive list of bases for an emergency tenant remedies action. Other change here is to make this procedurally work a little more like what I would say like an order for protection, where the tenant files a request and the court orders a remedy and then schedules a follow-up hearing. We were seeing some courts that would say, okay, you got this case, we're going to schedule a hearing for next Friday, but no relief to the tenant for this emergency. And so this hopefully will clarify the expectation that the court deal with the emergency if the court is convinced that the emergency exists, rather than just wait for a hearing on. The filing fee also was reduced for the emergency tenant remedies action. People also call them ETRAs. Early lease renewals, this was to get at an issue where a landlord will, and we saw this more in the student community, college community, where a landlord would say a couple months in the lease, you have to decide right now if you're going to renew this lease 10 months from now. And so this basically delays the landlord who wants to have that conversation, has to wait until 6 months from expiration of the lease, can't kind of jump into that right away. termination of lease upon infirmity of tenant. This is what this created a right of a tenant who has health issues and needs to move elsewhere to get out of the lease. It's patterned. It's similar to the law that we have that allows a domestic violence victim to get out of a lease. So there are a number of definitions here, but basically this allows a tenant who needs to go to a facility that they can get out of the lease by giving a notice and attaching some documentation of that need to do that. And so we have a number of definitions related to medical care facilities, medical professionals. Subdivision 2 really gets at the type of notice that the tenant has to give. So how the tenant can terminate the lease, and then the type of notice is in subdivision 3. And that was effective January 1, 2024, but again had this language about leases entered into or renewed after. So unfortunately, in my view, this one, like the privacy law, is going to have this somewhat gradual application to tenancies over, probably the next year.
Larry, we have another question if you're.
Yep.
The question is, would a radon level above the MDH max safe level recommendation meet 504B 381 subdivision 2?
Let's see. Well, first of all, I think it would fit in an emergency tenant remedies action, possibly as a condition that poses a serious or negative impact on health or safety. So that's not immediately answering your question. So this would be changing 504B 381 that applies right now. So I think that cause would fit here. Now, the other question is, would that fit into 504B 161? And so let me just take a quick look at that. So you can't see that right now because unfortunately the type of Zoom meeting we have today doesn't allow you to see me toggling from one screen to another. But 504B 161 subdivision 1, number 2 says keep the premises in reasonable repair, I think, and that's a very general provision. I think that that these facts would fit that. In other words, that would be a property that's not in reasonable repair. So I think it would be a violation of 161. But I think the remedy that would work best for the tenant would be to ask the landlord to deal with it. If the landlord doesn't deal with it, to file an emergency tenant remedies action and basically make the argument that it fits under number 10 here.
And then before you continue, we have another unrelated question here. The question is, do you know the reasoning in Ramsey County behind switching from referees to judges? Will this change likely occur in Hennepin County?
Okay. It's really between every district. Well, right now, we have a law that specifically started housing courts in Hennepin and Ramsey County. I worked on that law back in 1988 and 89. So it set up this pilot project that allowed both of those counties to do it. And then as we saw over the last few years, a number of other counties went down the road of saying, we want to have some referees too. And so you have a number of districts around the state that have been using it. Nothing in the pilot project or anything else requires a court system to use referees instead of judges. I think courts that use them tend to use them in more high volume areas that, so there are a lot of cases that are moving fairly quickly, involving people that are less likely to be represented. So it really helps to have a judicial officer who's more up to speed on the nuances of the law than when you have counsel on both sides. So I think there can be a real benefit to court systems having that kind of specialization. wouldn't necessarily have to be a referee, but in general, most of the courts like to kind of have the judges in more generalist positions within broader categories, like I've got a civil block or I've got a criminal block. So I don't really know what's going to happen there. I don't know if this is a budgetary thing, if the court has decided it would rather have more judge positions than referee positions. But I think in general, referees can be utilized well in any district. Okay, now I just wanted to, with this slide, remind people that some of the things that we already discussed were not just limited to evictions. So the non-payment of rent obligation of landlords, whether they file an eviction or not, they got to give that 14-day notice. And some of the other things we discussed in terms of privacy, minimum heat, and the like. So if you have this slide up on your computer at some point, you get to this slide and you clicked on the link, it would take you back to those earlier slides. Okay, we're getting close to the end here. Sober houses, I think, always had been governed by landlord-tenant law. Landlord-tenant law, the definitions of landlords and tenants are in 504B001. And when you look at those definitions of like residential building and landlord and tenant, I think sober houses fit into that category. But anyway, there was kind of enhanced regulation and governance of sober houses in chapter 61. And so it has some language about what is a sober house. The reason I'm including this here is it does specifically say that sober houses have to have written policies regarding evictions. And the use of that word eviction, which is a term of art, even though there isn't a cross-reference over to 504B, strongly suggests that this intends sober houses to follow 504B and to have policies that tenants know about when they're going to file evictions and when they don't. And so now I'm going to move, and residents have a Bill of Rights. A lot of this isn't specific to what I just said related to evictions, but since I had the law here, I figured I'd just throw the whole thing in. There was no effective date for this law, so it went into effect August 1. Now, there was a provision in the cannabis law, chapter 63, that allows sober houses to prohibit different types of cannabis use on the property. So that's really it for what I was going to cover today. One of my jobs is I work at Homeline, and we've been presenting monthly detailed seminars on subtopics of what we discussed today. And the slideshows and recordings, it should be and instead of an R, are at this at the Homeline website. And all of those were an hour and a half. So for instance, we did an hour and a half just on the 14-day notice. We did an hour and a half just on the cannabis. And so, I mean, I think this training hopefully is adequate for you. But if you want to go into a much more detailed kind of analytical framework of the topics we've discussed today, you would have that, and you can look at the slideshows and you can listen to the recordings if you want. So with that, we are at about 1:15, and I'm free to take any more questions, either about the piano in the background. Here, I'll put the piano in the background. The piano in the background, or anything that we've discussed today.
While we're waiting for questions to come in on the chat, I guess I'll just kind of ask generally, do you see, I mean, this was obviously a big year for changes to the landlord-tenant laws. Do you see any other changes coming up in future sessions?
Yes, I do. This is a lot that changed this year, but part of it is that many of these proposals had really been sitting on deck for about the last 5 years. When we had divided government and we had the Democrats and the majority in the House, Republicans and a majority in the Senate, a number of these passed the House, but they didn't get heard in the Senate. when the power balance shifted a little bit and the Democrats also had a small majority in the Senate, then the Senate started hearing these bills that had been parked for the last few years. And so that's why a lot got done. Very little of what happened this year was really a brand new issue for this year. And so I suspect that we're going to see more proposals this year now that the stuff that was on deck has kind of gone through the system. So at Homeline, we're looking at that. There are other organizations looking at that as well. There are a lot of really old landlord-tenant laws here. I mean, landlord-tenant laws date back, the statutes actually date back, some of them, to our territorial laws. So we had territorial laws of 1851. We had some landlord-tenant laws there, mostly in the eviction area. And they really stayed, I would say, in suspended animation for 120 years with no significant changes at all. And then there were some piecemeal changes that started basically around 1971. So you see our habitability law, laws related to security deposits, retaliation, things like that. And but even now, those laws are over 50 years old with very little change. And so one of the things we've been doing at Homeline is looking at, well, let's go back and look at some of those laws and see if they should be modernized. For instance, the habitability law, 504B 161, it had no enforcement language in there at all. So we later had some laws that then provided for some enforcement. But so part of what we're doing is taking a look at those and seeing how they could maybe be more suited to landlord-tenant relationships right now. Like there's nothing in 504B that talks at all about how should electronic communications be treated when there's an obligation to do something in writing, like a written notice. Can that be done by text? Can it be done by chat, by cell? And so it doesn't say anything, even though that's way lots of people communicate these days. So I think there's a real need for that type of modernization. And but we'll just have to see what happens. But I'd be shocked if there are no new changes in 2024 that would go into effect 2025.
Great, thank you. So we have had a couple of questions come in, including one about the piano, but before we get to that, there is a question: can these laws be used to help the unhoused and their property, or to stop the endless cycle of mass evictions and property destruction?
Okay, yes and no. I think that the changes to evictions are providing more due process. I think it's going to maybe lead to less evictions. I think the 14-day notice is going to lead to less evictions. And evictions on people's records is a significant contributor to homelessness. So homelessness has a couple of factors. One is, do you have the ability financially to pay to be housed? But also related to that, do I have a record that makes it hard for me to be housed? So anything that can reduce evictions is going to have some indirect impact on homelessness. Anything that helps tenants get expungements where appropriate is going to help with homelessness. But these laws don't do anything to change the economics of homelessness. And homelessness is, it's kind of off topic a little bit, but it's for a lot of people, it's economics. And if you can't afford to live in a home, it's an issue of either you don't have enough money to pay for this rent. And the way you change that is you increase income and/or you reduce the expense of housing. And that can be done through government programs, but it has a cost. It costs money. Increasing the minimum wage has a cost. Rent control has a cost. So all these things have a cost. But the idea that without addressing tenant incomes and tenant rents, um, you're not going to change it. You can make a dent in it, but you're not going to end it.
Thank you. We have another question. Can you touch on ESA requirements?
Hmm, not exactly sure what ESA is. Maybe it's an acronym I know. If Robert, if you could put in a definition of ESA, probably something I know and I'm just having a senior moment, but I'm not sure.
All right, we'll wait for the clarification on that. And then we did have a couple of questions about the piano. So while
Okay.
we're waiting, if you wanna cover that.
Okay. So it's a 6-foot Yamaha Grand. In my other life, I'm a professional jazz pianist. I majored in music education before I got sucked into the law, and I was a high school band director, and I've kept my chops up. That's what musicians say about their skills. And so I play at the Dakota, different jazz venues, jazz festivals, record CDs, that type of thing. Okay, well, while we're waiting for Robert, I'm just going to do a quick Google search for Minnesota and ESA and
We
see.
we have
Oh,
had
emotional support dog, maybe.
yeah, emotional support animals was a suggestion in the chat as well. So
Okay. Yep, emotional support animals. Okay. Um, I'm not totally up to speed with that, so I don't want to misspeak. But my understanding is that there are anti-discrimination laws that make distinctions between service animals and emotional support animals, with landlords having a greater obligation to accommodate a service animal than an emotional support animal. But I know that's kind of a weak, mushy answer. So one of the things I can do is when we're done today, I have looked at this issue and have done a little research on it, but I'm just not coming quickly to my head. So what I can do, Sarah, is after we're done, I could do a little research and send that to you, and then you could in turn send that to the group.
absolutely, be happy to do that. I don't see any other questions in the chat. If you do still have questions, please feel free to enter them at this time. Um, and while we're waiting for that, Larry, just want to thank you again for this presentation. I think this has been immensely helpful, having all this information about the changes in one place. So thank you very much for your time today. And we'll give it a couple more minutes to see if there are any other questions.
Okay, sounds good. And if we do another one of these sometime, I'd be happy to lead you in with a tune.
Terrific.
And the offer still is out there. So if people have questions afterwards, Sarah will send you the slides. You can also find contact information at my website the very first item in the chat here was a link to a section of my website that houses these slides. But also I have a contact section there as well, and I'm happy to talk to folks about this.
Great. Well, I don't see any other questions, so we can go ahead and wrap up there. Thank you very much again for your time, and thank you everyone for attending. We will get the slides and the recording posted as soon as possible. So thank you, everybody. Thank you so much, everybody, and have a great day.